Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce and Cordell podcast. Scott Trout, Managing Partner, CEO of Cordell and Cordell. And today we're going to bring you more information as it relates to divorce and even modifications when we're talking about custody. And as we do our podcast, as always, and I know you get tired of hearing me say it, but it isn't legal advice. Don't take it as such. That can only happen in a consultation. That is a one-on-one meeting with an attorney who can actually give you the legal advice that you need and understand your facts, your circumstances. And so really this is an educational, informational, and that's really why the podcast was started during COVID, was to just get you more information so that you're equipped when you have a conversation with an attorney, like my guest today. It can be a fruitful one, it can be productive, and it can serve as a good roadmap as you begin the strategy of your case. So welcome, litigation partner, senior litigation partner, Lisa Karges. Welcome to the program down in Florida.
Thank you.
So let's talk about it. It's really difficult. We just, guys talk about custody. They think about custody. And one of the things about doing a consultation with an attorney is to try to create a strategy that results in one of the more favorable outcomes. But we also have things in every state and county, and it's a little bit different when we talk about, for example, evaluators or guardian ad litems and how those are done and what do you do and what does it mean? And attorneys often use these terms and the public and a layperson just hears it and they don't understand. So that's kind of what the podcast is here to do. Let's break it down. What is, for example, a custody expert or evaluator? What in Florida particularly, what would you typically see and what would that mean when you're talking about custody?
So one of the tools in our toolbox is to utilize a neutral third party. And that's really what a custody evaluator is. They're a neutral third party. Oftentimes they're a clinical psychologist. Their role is really to determine what the best interest of the child is and to make recommendations to the court regarding what parenting time should look like. So sometimes they're, like I said, they're a clinical psychologist. Other times we call them guardian ad litems. Other times they're just social investigators. So every jurisdiction has its own term for what they call them, but they all fulfill the same role, which is really to notify the court what the best interests of the child are and what the court should do.
So how do you get one? I mean, can you hire one privately to do this analysis? Do you have to have a court appointed? Does everyone get interviewed? Let's kind of walk through that perspective.
Well, in Florida, it can be either. Sometimes the court will sua sponte, meaning on their own, appoint someone when they think there's a difficult fact pattern before them. Other times, one parent will say, hey, I see alienation happening here, or there's the specialized problem that my child has, maybe a mental incapacity or physical incapacity, or maybe it's just your average run-of-the-mill, we don't agree, and we need someone to help us out. So a parent can also, through their attorney, petition the court and say, hey, can you appoint a neutral person to help us out here?
Yeah. And so I know, I guess the common mistake, because I'm a fan of the evaluator. You talk about a psychologist, someone who's trained to use testing techniques, observations. That's kind of what they've been schooled on, and versus a guardian ad litem, because I know someone's coming to me before saying, well, yeah, I've got a custody evaluator. Oh, who is it? Well, it's one of those guardian things. And I this is my soapbox. I talk about guardian ad litems, and I'm not a huge fan of guardian ad litems because, one, at least in Missouri, they're you or me. They're just attorneys. Mm-hmm. I am not trained. I am not skilled to do a full custody evaluation. I can do interviews. I can get feedback, talk about that. But I mean, what is the difference between those two from your perspective? And then I'll give you my thoughts on those and kind of what's the difference.
Well, I tend to agree with you. A guardian ad litem can have that background of being a social worker or psychologist or mental health professional, but they don't have to be. They can be just an average licensed attorney. And in Florida, under our statutes, that's the only skill they actually need to do the job. Now, is that the greatest for the case? Sometimes yes, sometimes no. It kind of depends. But having someone with a mental health background, always the better scenario. They are an expert. And a guardian ad litem is not an expert in court. They're a neutral third party that testifies, but they don't have that expert designation behind them that is just one step above, and something that the court probably puts more weight behind.
I would say that they are third parties and they are neutral until they make their decision and they're going to say, this is my recommendation. And it's interesting. I always I guess paint the picture for our listeners. And that is, you have the plaintiff's table or the petitioner and then the defendant or respondent. That guardian tends to sit on one side or the other because there's no other place to sit. And lo and behold, they're going to sit where they align. If they're going to be with the petitioner, they're going to sit over there. Now you've got two attorneys against yourself. And I just, might as well hire a licensed plumber to do the same thing. And I know that sounds rough and maybe it sells them short. But again, there are spots in particular circumstances. I'm a fan. I would much every day of the week probably have a psychologist come on board. It's their training. And they do carry more weight, I hope, than that. But let's just assume for the moment we're talking today evaluators. What do they typically want to see, though? So clients go, okay, good. You've sold me on the evaluator and a psychologist. What do they want to see?
So it really doesn't matter what type of evaluator you have, whether it be a guardian or a psychologist. What they are looking for is a parent that has the understanding and ability to meet the child's needs, mentally, physically, and emotionally. They want someone that can provide a calm, safe, and stable home. And they want someone that can work with the other parent in an effective manner. Someone that's really moved beyond hostility and knows that being a bad partner doesn't mean being a bad parent. They are really looking for that whole package.
So evaluation, okay, I'm set. I mean, obviously it means we need some preparation. But so when I go in there and you talked about what they want to see, what do I expect when I go with my meeting? And I talk to them. Am I with an attorney? Am I by myself? What is it that I would expect?
So usually the first step in the process is to fill out an intake form and to have an initial phone call or an initial meeting. That's usually done without an attorney present. The evaluator is just trying to get a feel for the background of the case, what the issues are, and I think kind of test the waters. It's like a meet and greet, really. In my cases with my clients, before that even happens, I'm sending a letter to the evaluator outlining all the issues from my client's perspective and trying to get our foot in the door as the first one to tell our side of the story. And that's really where an attorney can come in handy and key for a client in this process, is guiding the process through what these meetings are going to be like, and also kind of trying to put their best foot forward on the matter.
And I know I forgot to ask this as I was thinking through it, is who pays for all this? That's the question.
Well, it is an expense. And the more expertise you have, the more expensive it can get. Yeah. Sometimes there are certain jurisdictions that have a county program that's relatively inexpensive. You pay a flat fee. Other times you're looking at a private individual, and those are usually split by the parties, paid by the side requesting it. It just kind of depends.
Yeah. So I'm a big fan. I love experts. I don't, in very few cases that I've ever tried, don't have an expert. And I mean very few in the 31 years I've been doing this. We do a seminar we've historically over the years called 10 Stupidest Mistakes. And I've used the example of a custody evaluator. In one of my very first cases early on, I used a psychologist to do an evaluation. Now, it wasn't a full blown, it was our expert. So they didn't interview the other side, but it was imperative in our quest to get 50-50 custody. And it was an expense, but it was the best money ever spent because the other side didn't have an expert. And we didn't have to disclose the expert in Missouri because they didn't ask. And there wasn't any mandatory disclosure, no mandatory discovery, that type of thing. So, and the client always said, well, what do I do? What do I bring? Can I bring all my emails? What documents are needed? They want to kind of understand, is it their opportunity to prove their case? What is it?
So documents are going to vary from case to case. And certainly you need to have a discussion with your attorney about what's important and what's not, because you definitely don't want to provide information and waste a party's time with all this cost for things that aren't really needed. So for example, if your children are missing school and they're always tardy when they're with the other parent, then you need to have copies of those report cards and attendance records.
Yep.
But if your child's doing good in school, don't waste your time with documents like that. You want to provide what is important. So that being said, I think there's some things everyone is going to need to provide, no matter what your case is about. If you have an investigator on your case, you definitely want to provide a chronological history of your relationship with the other parent and with the children. Yeah. You definitely want to provide a daily diary that's going to document important events, conversations, stories, not only bad things, but good things, right? And good things about the other parent too. I think that's just going to build your credibility with an evaluator. And then finally, a list of collateral witnesses. So it's important to every case to have some third-party involvement. And the key here is really quality, not quantity. It's much better to have a few people that can provide really substantive information rather than a phone book of people that are just going to say, he seems like a good dad or she's a bad mom. Yeah. And so you want to make sure you talk to your collaterals in advance and you get their permission to list them and you talk to them about what they might say. Because the worst thing that could happen to you is you put someone on your list and the investigator calls them up and they hang you out to dry.
Yeah.
So you definitely don't want that to happen.
So, it all comes down to, and in a lot of these podcasts, we try to get some, what I'll call deliverables, things that people can act on in some regards, and today's no different. Let's talk about do's and don'ts. So you're listening, get a piece of paper and a pen out, and let's start taking some notes. And I think about some do's and don'ts. I mean, obviously, a lot of it is preparation, but my clients, if with unfettered, untrained, unprepared, would go in and say, "Well, man, let me tell you what kind of bitch this person is," and it's like, okay, let's be normal. Let's not try to be so crazy. And so do's and don'ts are so important when it comes to, an evaluator. And so let's list out some do's.
Sure. So I would say first and foremost, make sure your parenting time is your parenting time. So you want to be involved. If you're seeking custody, but you're not actually present when you have the opportunity to be, that's not going to bode well for you. So you want to be able to show the court that you made the best use of any time you were allotted, whether that be a lot or a little. Second, I would say anticipate the other parent's criticisms of you and try to ameliorate them. If the other parent's going to say you gamble, then stop going to Vegas. You can't change the past, but you can show you're willing to change your family's future. Right. And finally, my third tip would probably be use social media sparingly. So you want to refrain from those angry status updates. Don't advertise your single status on Facebook, post those drunk escapade photos. Just don't overshare because all of that is discoverable. And even if you're not providing it or the other side doesn't even know about it, sometimes investigators just look for that stuff. Yeah. So you want to make sure that you are very careful with your social media. So those are the do's.
Yeah. And you talk a little bit about, alcohol or gambling or whatever. It's always, I tell my clients, look, there aren't many sets of facts and circumstances that I can't help you with and to proceed your case forward. I mean, there are a few, child abuse, other those things are against children that really are going to be problematic for you. And when I talk about gambling, you use that as an example. Stop going to Vegas. Stop running from your gambling issue and start going to it, meaning, hey, okay, yeah, I had a problem. And now I'm in, Gamblers Anonymous. I have an alcohol issue. I'm in Alcoholics Anonymous. I'm getting treatment for it. I understand it's a problem. Own up to it. Run to it. Don't run from it. Because I think if I'm a judge sitting on the bench, I got some respect for someone who acknowledges their faults and wants to better themselves because no one's perfect. I mean, judge is not going to believe you if you come in and portray that I'm angelic my entire life. And, I'm the next thing closest to Jesus because it's just going to come across as fake. So yes. Let's talk about the don'ts. What is it you want to completely avoid when you're talking about an evaluator?
Okay, so I would say the biggest don't is do not interfere with the other parent's access to your kids or undermine their relationship. There is nothing a family law court is going to hate more than one parent alienating the children from the other. So you don't want to speak poorly in front of them. You don't want to add them to email chains, and you certainly don't want to let them decide whether or not they're spending time with the other parent. That is probably the best tip I could ever give a client in a divorce or modification case. Second, you don't want to discuss the litigation with the children. So don't coach them. Skilled investigators are really trained to detect that. And you can give your kid information that's age appropriate, telling them, hey, an investigator is going to come speak with you. I want you to be honest. I want you to be cooperative. And you tell them what you want to tell them and answer their questions in a cooperative and polite manner. And finally, be careful introducing those romantic partners into the mix. And I really say be careful, but what I mean is do not do it. It's immediately a red flag for an investigator. Your children have enough to deal with comprehending and coping the loss of their family. And there is no way that introducing a potential step parent or step sibling can help you, but it certainly can cause damage to you. So just don't do it. Totally.
I always say, just wait. There'll be plenty of time to go get on whatever farmersonly.com and find that love, match for you to hang out with you and your kids, just not during the case. I think you can wait and it'll be just fine. You got plenty of life ahead of you. There are the in-home visits, where someone wants to maybe surprise, or maybe it's planned, whatever it may be. Talk about in-home visits. What do you do? How do you handle it? Who's there? What is typically would you expect, and kind of maybe talk a little bit about that.
Yeah, so definitely as part of this process, no matter who you're using, a guardian or investigator, you're going to have someone come to your home. That's just naturally part of the process. And so you want to make sure that you're putting your best foot forward. You want your home to be neat and clean, hospitable. When the evaluator arrives, you want to invite them in, offer them a drink, a non-alcoholic drink, tell them they're free to wander around. You want them to have positive memories of your home. So one thing that I always advise my clients to do is to have pictures of the other parent around their home. And I often get a lot of pushback on this, but your potential dislike or hatred for the other parent may be severe, but your child should at least have a photo in their room, on the dresser or the wall, maybe the whole family together, not just of the other parent. And remember, your children are there usually during this home visit as well. So they're being observed. You're being observed. Don't let your kids veg out and watch TV and eat candy on the couch. Have an activity planned. You usually know these home visits are coming. They're usually not spontaneous. And don't be afraid of tantrums. You can use appropriate discipline. In fact, you're expected to. And having a situation arise like that naturally is a really good way for the investigator to observe how you truly are as a parent.
Yeah, I laugh because I was giggling when you say, don't serve them a drink or alcohol. Even if on the hot day, don't offer them a margarita. And, at 9 in the morning. I know it's a lot of preparation, I have to think. Sit down with your attorney and you don't want to fake it. I've had clients, I always remember we were in a trial and he happened to have lost his job, but very wealthy, very well-to-do. And instead, he wanted to portray himself, despite my objections and insistence, don't do it, that he couldn't do anything other than mow lawns. So he came in basically what you would wear to go mow your lawn on a 103-degree day. And judge read right through it. And I'm like, you're not fooling anyone. The judges have seen everything. And so you can sniff out someone who's trying to portray something that they aren't and try to be real, but avoid the anger issues, the thing that made you mad. But I love the tip. The tip of having family pictures is great. I had not heard that one before. I think that's fantastic. And I get the pushback, but you're going to be a separate family anyway moving forward. You got to figure out a way to co-parent. And if you can't co-parent, that's a red flag anyway for a judge, if not even evaluator. You've got to figure out a way to do it and support one another from afar. And I know you two don't get along no matter what, but I think that's an outstanding piece of advice when it comes to that. So any parting tips for the conversation, the interview, the meetings, whatever it may be?
Well, I think if there's one thing I would want someone to take away from this podcast, it is focus on the positives of you, and you're going to get a favorable outcome. Yeah. Not the negatives of the other side. Those are going to come out naturally. If a parent's really a bad parent or they have all these problems or issues, that's going to surface. You don't want to be the one to do that. So when in doubt, talk about your kids and yourself and stay away from the other side.
Yeah, be honest with your own weaknesses. I mean, every parent is different. Each parent brings something to the table, but it doesn't mean necessarily that you're going to have to figure out how to fill that gap moving forward. And I think that's part of the educational process. It's interesting. I was just on a podcast as a guest on Art of Fatherhood, and they talk a lot about that, about guys and kids, whether it's intact family or not, and how guys can learn and be better. And it's a great resource too. And just being real and honest and understand your strengths and your weaknesses. So great stuff, Lisa, today. I appreciate it. We could go on and on for an hour or so, but this is all the time we have. So thanks for joining today.
Yes, absolutely. Thank you.
Well, keep tuning in and watch our social media posts for our upcoming virtual town hall here this month. That's an opportunity, if you don't know what that is, where you can register for free. You can log on over the lunch hour for a half an hour. There'll be a panel of Cordell and Cordell attorneys. You can ask questions and get answers right there live by just submitting it. And you can do it from the comfort of wherever you are, via Zoom, via whatever it is. So check us out. You can either go to cordell.com, check out our social media. You get more information on those virtual town halls that we hold monthly and different topics, different guests. It's a great opportunity for you to join, as well as these podcasts as we drop. You can subscribe to those on Apple, iTunes, and you'll be alerted every time we drop it as well. If you want a consultation, you can do it online at cordell.com. You don't have to pick up the phone. You can schedule it right there, find an office closest to you, and you can do that either in person, phone, or through the internet or Zoom, FaceTime, whatever is easier and convenient for you. Or you can give us a call, 866-DADS-LAW. So until next time, have a great week.